Hello and welcome to Legally Speaking with Rest the Case. Today we're diving into a fascinating and sometimes controversial area of international law, Investor-State Arbitration or ISA. For those unfamiliar, ISA is the process where foreign investors can bring claims directly against states, often under investment treaties. But how is this different from regular commercial arbitration? Why do investors prefer it? And what does it mean for countries like India that have found themselves as respondents in high profile cases? To help us unpack these questions, explore the criticisms, and understand landmark cases that have shaped the landscape, we are joined by Advocate Sidharth, who brings deep expertise in international arbitration. Together, we'll also discuss how states can strike a balance, protecting their sovereignty while attracting global investments. So let's start by understanding the basics. Advocate Das, to begin with, what exactly is investor state arbitration and how is it different from commercial arbitration?
See, commercial arbitration is a contract actually. But here, if I am talking of investor-state arbitration, let's talk of a free trade agreement or a bilateral treaty. Those things are involved. That means this country, the state, and the investor. There are two things over here. For example, a foreign investor can take a particular government, a state government, or a country's government, to a neutral international tribunal, not the host country's, court. If the action of the state allegedly harm the investment of the foreign investor, example, cancelling of a license or maybe blocking of a project, those things normally fall into the investor state arbitration. I'll just give you one or two examples to be, so that it becomes easier for you. Let's take a case. It's TechMed versus Mexico. That was Mexican government in 2003. There was a landfill operating permit which wasn't, renewed. You know, and the arbitral tribunal held Mexico breached treaty standards. That is indirect expropriation, and there was no fair and equitable treatment. Or for that reason, let's take uh, there was an authorization revocation in Bear Creek versus Peru in 2017, wherein the Peruvian government revoked a mining authorization, and the tribunal found Peru liable because it was partial expropriation, and which you see, when there is a bilateral investment treaty or a free trade agreement, the state cannot take a whimsical decision on its own. Okay. The doorway over here is usually a treaty, sometimes a national investment law that pre-consents to arbitration. It isn't just a private contract between an investor and a ministry. Okay, tribunals apply public international law standards, that is, think fair and equitable treatment, no unlawful expropriation, non-discrimination, not only the local contract law. The focus over here in ISA is on state measures, that is, laws, regulations, tax actions, court delays, not simply whether a company breached a clause or not only when a company breached a clause. So it's about how the country, in fact, by state, I mean the country, treated the investor overall. Mostly money damages with interest, sometimes a declaration of breach. Tribunals do not jail officials or rewrite laws, but their hours are widely enforceable across state assets. So that's the basic difference between commercial arbitration and investor state arbitration and ISA.
Okay. And why do investors prefer arbitration over domestic courts when dealing with states?
See, in arbitration, you have to have a neutral forum. That's the basic. Any arbitration, it's commercial arbitration, ISA. The basic thing that comes into picture is that you need to have a neutral forum, not the local courts. Normally these things are heard by international tribunal. The parties pick. Example, you can pick ICSID or unilateral rules. So the investor over here is not relying on the host state's own judges. Then it has global enforceability. Since you are choosing UNICITRAL or ICSID rules, so it has these ISA awards, the Investor State Arbitration Awards, are designed to travel. ICSID awards must be treated like final judgments in all ICSID member states. New York Convention helps enforce non-ICSID awards in 170 plus countries, far easier than enforcing a foreign court judgment. And then there are specialized tribunals. You know, arbitrators are investment and damages experts. That is public international law, valuation, project finance. So they can assess things like regulatory impact and compensation models more rigorously. And last but not the least, there are more predictable timelines and less potential risk. Procedures are set by arbitration rules and a tribunal calendar, that is case management conferences, fixed submissions, reducing delay and insulating the dispute from domestic political pressure.
Right. And what are the typical treaties or agreements that allow an investor to bring claims against a state?
See, there are two things: multilateral investment treaty and bilateral investment treaty. Two country or multi-country treaties that promise fair treatment and no unlawful expropriation, and crucially give consent to arbitration. That is, they should have this investor-state dispute settlement. Then there are free trade agreements with investment chapters, broader trade deals that include the same protection, plus this ISDS, that is Investor State Dispute Settlement. So investors can sue if those standards are breached. Then there are host state investment laws, some country statutes, pre-consent to arbitration for qualifying foreign investors. State contracts, there are state contracts with investor state dispute settlement. Big projects may add an this investor state dispute settlement clause, but treaties are the main doorway. Whatever the treaty is there, whatever treaty is signed is the main doorway because they bind the state at the international level.
Okay. And many critics argue that ISA favors investors over states. Do you agree with this perception, or how fair is this perception?
50-50. I would say 50-50, but effectively saying investors don't always win. Many claims are also dismissed outright, or states win partially, maybe the countries win partially by limiting damages or defending on jurisdictional grounds. I'll give some examples some examples, some case laws, so as to make it clearer. Philip Morris versus Uruguay, that was ICSID arbitration of 2016. Uruguay's tobacco rules were upheld. Tribunal rejected all the claims and ordered Philip Morris to pay somewhere around, if I remember, $7 million in costs. Then there is also partial state win. You can say MTT versus Chile. That was also ICSID. It was in 2004. Investor proved breach, but tribunal found contributory fault and half the damages to 50%. About 6 million awarded in that. So you see, not every time the investor wins. It depends. It depends. If there is some rules which go against that treaty or something of that stuff. So there the state also wins. Sometimes it is partial, sometimes it's absolute also.
Yeah. Okay. And transparency and legitimacy are questioned in the ISA often. Do you think reforms are necessary in the ISA?
To an extent, yes. To an extent, yes, because this is, investor state arbitration. As far as India is concerned, it's very new. There are 2, 3 cases which happened, like Vodafone. You must be knowing Vodafone, which happened, and one or two more cases happened. It's very new. So I feel, as per my opinion, there should be more sunlight. That is transparency. Open hearings and published documents let the public and media see what's happening, which actually builds trust. Conflict of interest and third party funding disclosure means arbitrators reveal ties and funders and name, reducing hidden biases. Then there should be time and dismissal filters weak or abusive claims first. Page limits, tight time tight timetables and fee caps stop cases from ballooning and push both sides to focus on essential. And then there is quality control, that is the appellate light. A narrow appeals step to fix clear legal mistakes, not a full retrial, improves consistency without turning the system into endless litigations. Rules are evolving, but use matters. Modern rule sets, that is transparency add-ons, expedited tracks exist, but states must write them into their treaties and contracts. It may be a BIT, may it be a FTA, may it be a MIT, and tribunals must enforce them, sanction delay, award costs, and actually publish materials. So these are some of the things which I think are necessary to bring into this ISA, so as to make it give more sunlight to it.
Right. And what challenges do developing countries face when dragged into arbitration by foreign investors?
There are a few challenges, no doubt. Let's say the capacity gap. The first comes, the thing that comes into mind is a capacity gap. That is small teams versus big guns. Many ministries have two, three lawyers. Normally, they are empaneled. Investors arrive with a global firm plus valuation and industry experts. That mismatch can overwhelm strategy, evidence review, and damages modeling. Then there is paperwork and coordination, the evidence match, you know. Investor-state dispute settlement needs emails, minutes, permits, tax files, often across 5, 7 agencies and states. Missing or inconsistent records, they slow the defense and can invite adverse inferences. Then there is budget strain. In fact, this budget strain is related to arbitrator fees, tribunal cost, e-discovery, translations, and quantum experts can run into millions. Even if the state wins, unrecovered costs still bite the public purse. Regulatory, something related to the regulatory, that is fear. Normally, fear comes in. Officials may delay health or environmental rules to avoid being sued. Well-documented non-discriminatory regulations with public interest evidence usually survive, but the fear alone can freeze action. Then practical fixes, it can in one breath stand up a central ISDS cell, impose document holds early, budget for damages experts, use model pleadings timelines, and pass laws requiring impact assessments and transparency. So good faith regulation is both defensible and defensively recorded.
Okay. And India has been a respondent in few of ISA cases like White Industries and Vodafone, like you mentioned. What
Yeah.
lessons can we draw from these?
See, White Industries, are you aware of what was this White Industries Australia versus Republic of India happened? There was a most MFN clause. There was an MFN clause which was, the India-Australia bit, the bilateral investment treaty did not say courts must give an effective way to enforce rights. But India and Kuwait bilateral investment treaty did have that promise, which was known as the effect means standard. Because India's courts took years to enforce White's ICC award, the tribunal held India liable and granted damages. That means you have to have the most favored nation drafting matters. The takeaway from this is MFN drafting matters. Loose wording can pull in higher standards from other treaties. So this actually shows how systematic excessive court delay can breach investment treaty obligations. The investors' award sat unenforced for roughly 9 years. The tribunal found state responsibility even though the original dispute began as a commercial one. So here the takeaway is speeding up enforcement isn't just good governance, it requires treaty exposure. Now, if you're talking of Vodafone, that's a tribunal seated at the permanent court of arbitration held that India's retrospective tax demand. Retrospective. Laws normally cannot be retrospective in all the cases as far as tax is concerned. When I've already paid a tax, so I have to pay a higher tax and that too applied retrospectively. Demand breached the Netherlands-India bilateral investment treaty, including FET, that is fair and equitable treatment, and awarded costs to Vodafone. So from this, we can say that model bilateral investment treaty shift, that is narrower policies, it should be policy space friendly. India's model text tightens what qualifies as an investment and equitable treatment to a closed list, removes the most favored nation, adds robust tax and regulatory carve-outs, and requires investors to adjust local remedies. Before arbitration, preserving room to regulate health, environment, and financial stability. So what India did is they, in the model bilateral investment treaty, they shifted. So they learned from this White and Vodafone, and also from Kane Energy, if I remember. That was also where India was found in breach, and US around 1.2 billion or million, I don't remember, was awarded. Then there was a policy change, which this policy change which I talked about, this led to a settlement. So this is what we learn from the mistakes that have been made actually.
Right. And from a lawyer's perspective, what are the key legal strategies in handling ISA disputes?
Uh, Legal strategies. Okay. Uh, let's segregate this. Uh, First is jurisdiction. That's the first line of defense. You have to first check the consent. Did the state ever agree to arbitrate this kind of dispute under this treaty or law? Then check the standing. Is the claimant truly an eligible investor with a qualifying investment? Okay. Then check legality. If the investment involved fraud or corruption, claims can be barred. Then if the investor already chose courts or another treaty route, the treaty may lock them there. No second bite. Then split the case. Ask the tribunal to hear jurisdiction admissibility first. If the claim fails there, the case ends early. It saves time and money, then and pressurizes the claimant to prove the basics before everyone spends on damages. Then build a policy record. Put a contemporaneous evidence on table, impact studies, health environment data, stakeholder consultations, non-discrimination analysis. So consistency and good faith. Similar cases treated alike, reasons recorded, alternatives considered. This turns a policy hunch into a defensible public purpose. Attack causation and valuation. Approved losses came from the market shift, operational issues, or commodity prices, not the state's measure alone. Challenge any rosy forecast, scrutinize discount rates, country risk, but for scenarios, argue contributory fault and limit interest. Use amicus and transparency because not everybody is an expert. Not every lawyer is an expert in every field. So invite amicus curiae briefs, public health or environmental bodies to support the policy rationale with an independent evidence. Seek open hearings and publication of filings and awards where rules allow. The transparency helps tribunals credit bona fide regulation and counters secret court narratives.
And do you see ISA evolving in the future, maybe towards a global investment court system?
Yes, as I said, more transparency, expect wider transparency, routine early dismissal of weak claims, and mediation layers or ombudsman layers to resolve disputes before full arbitration. Then discipline the damages, convergence and valuation methods, discounted cash flow methods, tighter discounted cash flow methods, realistic country risk and discount rates, limits on interest and speculative profits to curb outsized awards. Then growing appetite for a narrow appeal on legal errors to improve consistency without retraying facts. Then multilateral investment court, the EU court, the European Union backed court with appeal idea is plausible. That is, permanent judges are there, standing appeals body is there. Even if not universal soon, elements are seeping into treaties. Evolution, not abolition. So the bottom line over here is evolution, not abolition. A leaner, fairer, more predictable investor-state dispute settlement with clearer treaties, faster procedures, and sturdier public interest space is required.
Right. All right. I think we have addressed all the questions that we had for today. Is there anything that you would like to add before we end today's podcast, sir?
You have to ask me because this is a very new topic
Yeah.
and India is still evolving and we are still
Yeah.
evolving. I think there should be more transparency in the BITs, FTAs, and the MITs which
Yeah.
are being drafted. and the policy changes should be there to reduce the costs and give more transparency so that early judgments are out and cost is less, reduce costs.
Got it. All right. And with that, we have learned today investor-state arbitration sits at the crossroads of law, economics, and politics. It offers investors a powerful tool for seeking redress, but it also raises tough questions of fairness, transparency, and national interest. From landmark disputes involving India to global debate on whether we need an international investment court, one thing is clear: ISE is evolving, and so must the strategies of both investors and states. A big thank you to you, Advocate Sidharth Das, for sharing such valuable insights, and to you, our listeners, for joining on the episode of Legally Speaking with Rest the Case. Until next time, keep questioning, keep learning, and stay legally informed. Thank you so much.